Is the Dowry Prohibition Act of 1961 still relevant in our modern society? That's a question worth pondering. The Dowry Prohibition Act, first enacted in the year 1961, stands as a landmark legislation in the fight against the age-old social evil of dowry in India. This act, in its original incarnation, declared dowry as an unlawful practice, making it a punishable offense. The main objective was to eliminate the dowry system, which was, and sadly still is, a significant cause of violence and discrimination against women in India. However, the act, as it was initially framed, had many loopholes. Recognizing these shortcomings, the Indian government made the First Amendment in the year 1976. This amendment introduced a new definition of dowry, broadening its scope to include any property or valuable security given directly or indirectly, at or before or any time after the marriage. The amendment also made it mandatory for the parties to list out the gifts exchanged during the marriage. Despite these changes, the act still lacked the teeth to effectively combat the dowry menace. This led to a Second Amendment in the year 1984. This amendment further strengthened the act by increasing the punishment for giving or taking dowry, and also for abetting the same. The amendment also made the offense non-bailable, with a minimum punishment of imprisonment for not less than 5 years, and a fine of not less than 15,000 rupees. The act was further amended in the year 2005 to make the offense of demanding dowry a cognizable and non-bailable offense. This means that the police could arrest the accused without a warrant and start an investigation without the permission of the court. The most recent amendment in the year 2020 has been a game changer. It introduced a new provision for the appointment of dowry prohibition officers, who are empowered to prevent and collect evidence for the prosecution of persons committing offenses under the Act. This amendment also made it compulsory for the bride and groom to disclose their income and assets at the time of marriage. So, to summarize, the Dowry Prohibition Act of 1961, since its inception, has undergone several amendments aimed at strengthening its provisions and making it more effective in the fight against dowry. It has evolved from merely prohibiting the giving and taking of dowry to broadening the definition of dowry, intensifying the punishment, making the offenses non-bailable, and finally, to appointing dowry prohibition officers to ensure its effective enforcement. However, the question still remains: is the Act, despite all these amendments, successful in eradicating the dowry system from our society? That's a question for another day. For now, it's safe to say that the Dowry Prohibition Act of 1961 is indeed a significant piece of legislation that has taken several strides in the right direction. But the road to complete eradication of dowry is long and fraught with challenges, and it's a road we must continue to tread for a society free of gender-based discrimination and violence.